Is everyone ready?
Yeah, no, I forget like what something for the Jesus. I don't think it'll be much.
Andy.
I actually really like it.
Appears to be a battery issue. Maybe.
I know. Well, it's like I don't really. It's like application center. Yeah, it's like yeah. I don't know.
You ready in Springfield?
Yes.
Thank you. Good morning, everyone, and welcome. I will now call this meeting of the State Board of Elections to order. Today is January 30th, 2024. The time is now approximately 9:33 a.m. We can all rise for the Pledge of Allegiance, please.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please, Amy.
Ms. Ballard-Croft. Ms. Cray. Present. Ms. Genovese. Present. Ms. McCory.
Present.
Mr. Turbin.
Present.
Mr. Brett.
Present.
Vice Chair Donahue.
Present.
Chair Watson.
Present. Madam General Counsel, the agenda calls for us to begin with the lack of apparent conformity of petition. May proceed.
Thank you. This is agenda item 1A of candidate Fazzini.
Now, hold on one second. You want to turn telephones off? Or on buzz you, or we'd appreciate that. Thank you. Continue.
Thank you. Candidate Fazzini submitted nomination papers for the office of alternative delegate to candidate Ron DeSantis for the 6th Congressional District. Candidate Fazzini did not sign their statement of candidacy, and therefore, under the board's apparent conformity policies, the papers are not compliant. Therefore, I recommend that the nomination papers be dismissed and that the candidate not be certified to the ballot.
I would move that we accept the recommendation of our general counsel.
Second.
Roll call, please.
Ms. Ballard-Croft.
Yes.
Ms. Cray. Yes. Ms. Genovese. Yes. Ms. McCory.
Yes.
Mr. Turbin. Mr. Brett.
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes,
Motion passes.
thank you. Is there a motion to recess the State Board of Election and reconvene as the state officers electoral board, please?
So moved. Second.
Roll call, please.
Ms. Ballard-Croft.
Present.
Ms. Cray. Yes. Ms. Genovese. Yes. Ms. McCory.
Yes.
Mr. Turbin.
Yes.
Mr. Brett.
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
Madam General Counsel.
Thank you. Before we proceed into our cases, I'd like to give everyone a little bit of background and logistics for this morning. I'd like to thank everyone for being here today. I'm Marnie Malowitz, General Counsel to the board. Today, the board will be hearing objections to the nomination papers of candidates seeking to appear on the ballot for the general primary election on March 19th of this year as established party, special judicial, or presidential candidates. For each case called, I will read a brief summary of the objection, recommendation of the hearing officer, and my recommendation on the disposition of the matter. We ask that the parties keep their arguments relatively brief, with the objector going first and the candidate going second. The board may grant more time for argument if they wish, but under Rule of Procedure 11, they have the ultimate authority to decide what oral arguments may proceed. The board has a number of cases to hear today, and the parties have already been given an opportunity to present evidence and arguments to their hearing officer. The board has been given copies of all of the objections, motions, briefs, hearing officer recommendations, and exceptions to hearing officer recommendations to consider, so there's no need to reconsider or reiterate every argument your side has advanced. Please also remember that no new evidence is to be presented here today. This is an opportunity to make legal arguments and explain your position to the board. Once the board has voted on your case, you can pick up a copy of your board order from Andy Nauman in Chicago, who is waving his hand over there, or from Jordan Andrew in the Springfield office. Hopefully Jordan is waving her hand.
Yes.
And I'd like to give a thank you to the board staff and especially the legal staff for all the effort you have put into these electoral board matters. I will proceed to call the first case. It's agenda item 3A. It's a special judicial candidate nominating petition for the March 19th, 2024 general primary election. So item 3A, Overturf versus Hopkins, 24 SOED GP 115. Objector Overturf, who is represented by attorney John Fogarty, filed an objection to the nomination papers of candidate Hopkins, who is represented by attorney Anthony Shuring. Candidate seeks ballot access as a Republican Party candidate for the office of Circuit Judge for the 2nd Judicial Circuit Tedeschi vacancy. Objectors argued the objection should be sustained and candidate removed from the ballot because he is not a resident of the unit that would select him as required by Article 6, Section 11 of the Illinois Constitution. And his statement of candidacy is invalid because he falsely represents that he lives in Franklin County, even though he has not abandoned his residence in Williamson County. The candidate filed a motion to strike and dismiss, arguing the objection pled insufficient facts in his petition and the motion was fully briefed. Both sides in this matter offered a number of records into evidence in this case, including voter registration records, driver's licenses, other public records, social media postings, and candidate testified on his own behalf at the evidentiary hearing. The hearing officer found certain portions of that testimony to be not credible. The parties agree on the applicable test for residency, and the objector bears the burden of proof. For legal purposes, residency is determined by physical presence and an intent to remain. Once a residency is established, it is presumed to continue unless or until it has been abandoned. Here, the hearing officer recommends finding that candidate established residence in Williamson County when he left his marital residence in connection with his dissolution of marriage proceedings in 2021, I apologize. That candidate has resided in Williamson County since that time. The candidate initiated a lease of a property within the judicial district in Franklin County in October 2023. But that the facts demonstrate candidate has not abandoned his residence in Williamson County. The hearing officer recommends finding that because he does not reside in the unit that would elect him as required by the Illinois Constitution, the candidate does not meet the Illinois Constitution's requirement that he reside in the unit that would elect him, and that he filed a false statement of candidacy in violation of Section 7-10 of the Election Code. The candidate filed an exception to the hearing officer's recommendation, arguing, among other things, that the hearing officer should not have independently researched candidates' divorce records. I agree with the candidate on that point. But that said, the hearing officer located no records, so none was considered and no harm was resulted. The hearing officer recommends, and I agree, that the candidate's motion should be denied because the objection petition was properly pled. Objector's objection should be sustained, and candidate Hopkins' name should not be certified for the March general primary ballot as a Republican Party candidate for the office of Circuit Judge for the Second Judicial Circuit.
Attorney Fogarty?
Yes, John Fogarty on behalf of the objector. We would ask that you accept the recommendation of the hearing officer and the general counsel. I'm happy to answer questions. The test for residency, I think all parties agree on physical presence and an intent to remain. I would suggest that the hearing officer is the person who is best able to judge the credibility of the witness, and in this case, the candidate, and determine whether his actions told a different story than his words. And I think that was the case here. The candidate here purchased a house in October of 2023 in Williamson County, and had set up a rental agreement in Franklin County at about the time this vacancy opened. The evidence showed that he was at this rental property a very scant amount of time. Only a handful of times would he have stayed there. Further evidence demonstrated that this candidate spent the holidays and had his children at his Williamson County residence, and it was fully furnished and full of all of his personal effects. So the overall result is that the candidate established his residency in Williamson County, and by his actions did not demonstrate that he relinquished that residency. And for that reason, I think that the hearing officer's conclusion is correct. We'd ask you to adopt it. Thank you.
Could you state your name, please? I don't want to butcher it.
Yes, ma'am. Yes, ma'am. Good morning. My name is Anthony Schuring.
Sherry.
Yes, ma'am.
Proceed.
Thank you very much. Good morning, and thank you for the opportunity to present. The candidate would ask that the board reject the hearing officer's recommendation and overrule the objection to his candidacy. I want to start first with the point of the hearing officer doing independent research. Your general counsel agreed that that was improper. There was a comment made on page 11 of the candidate's, or excuse me, of the hearing officer's recommendation. But I just want to read this to you so you can get the full context. The hearing officer was unable to locate a 2021 divorce case in Franklin County involving candidate. And then it goes on to say that representation weighs heavily against the candidate's argument in this matter. So what we have the hearing officer saying in this instance is he did independent research because there was no evidence presented at the hearing regarding the divorce. It was accepted by both sides that the divorce took place in 2021. The hearing officer did his own independent research on an issue that was not in dispute, could not locate the records, and then stated that his inability to find those records weighs heavily against the candidate's argument. So respectfully, I disagree with the general counsel that there's no harm done here. There's substantial harm done here because the hearing officer himself says that that it weighs heavily against his argument. And that's not the only, frankly, legal issue that we argue that the hearing officer either misapplied the law or misunderstood the law. We also argue in our exceptions that the hearing officer conflated residency with domicile. And I think that's best shown. There's a portion of the recommendation where the hearing officer says that, and he asks it rhetorically, this begs the question of where the candidate resided from 2021 to 2023, and then presents the three options as the Williamson County residence, the Franklin County residence that he rented, or his law office. And just as a matter of law, that's incorrect. If you're picking a domicile, those are the three options. There is a fourth option, no residency, because he was physically present in a particular area for a period of time, but he did not intend to remain there. And we cite the law for that proposition in our exception. But the fact that the hearing officer did not understand that that was an additional option demonstrates that he's conflating residency with domicile, which again cuts in against the candidate in this case. His misapplication or misunderstanding of the law cut against the candidate in this case. The third issue that we raise with respect to misapplication of the law is the hearing officer's apparent misunderstanding of the Dissolution of Marriage Act. Just at the outset, I have to say I never thought family law would come into an election law case, but here we are. He states that the candidate stated in his testimony that the reason that he initially started living in this Williamson County house was he was very blunt about it, frankly, to obtain a tactical advantage in his divorce. He thought that living closer to his children's school would give him an advantage when they were trying to figure out custody and parenting time. He said that he intended to live there for 2 years because after 2 years, the burden for reopening a divorce case becomes significantly higher. The hearing officer stated in his recommendation that the ability to modify parenting time at any point cuts against the legal argument that the candidate was making, which is just incorrect as a matter of law. I mean, after parenting time is established in a divorce decree, and that 2 years passes so the divorce decree cannot be reopened absent really exceptional circumstances, the burden shifts to being on the moving parent to be able to show a substantial change in circumstances. And at that point, moving is not a substantial change in circumstances. In fact, we cite a case in our exceptions. It's, I believe, a third district case where the parent was moving from Illinois to Germany, and that was not a substantial change in circumstances. And so as a result, I think it kind of logically follows that him moving from Williamson County back to Franklin County at that point would not work against him the way that the hearing officer believed that it would. And so as a result, we think that, and we argue in our exceptions, that the hearing officer's misunderstanding of the operation of the Dissolution of Marriage Act, again, cut against the candidate and led to this conclusion. And finally, we believe that the hearing officer considered improper impeachment evidence as a part of his recommendation. There were several instances where counsel for the objector asked the candidate about statements that were made in affidavits from third parties. The candidate submitted 7 affidavits in support of his effort to stay on the ballot. They included his realtor, his legal assistant, his contractor, his brother, and his neighbor at the Franklin County residence, all of whom said that they had had discussions with the candidate about his intent to return to Franklin County, and that his living in Williamson County was temporary. It was always intended to be temporary. He always wanted to move home to Franklin County. The objector, as an example, the candidate's landlord in the Franklin County property said that he had driven by the property multiple times and seen the candidate's car outside the house. Counsel for the objector asked the candidate how many times that the landlord had been in the home with or been at the property with the candidate, and his response was only once. And that answer was used to undercut the veracity of the declaration. That's problematic because the candidate would have no way of knowing how often, how frequently the landlord was driving through that part of Franklin County and saw his house there. So it truly doesn't undercut either testimony. Both can be true. And the fact that that testimony was used to undercut the candidate's credibility and the affidavit's credibility is improper. It's improper impeachment evidence, and we've cited multiple cases in our exceptions where that just simply can't be done. You can't use the writing of a third party to undercut a person's testimony, and vice versa. You can't use a person's testimony to undercut a third party's writing. And so the fact that that was done is another reason why the hearing officer misapplied the law. On top of that, we have issues with the representations about some of the evidence that was submitted. I mean, as an example, the hearing officer states in his recommendation that the candidate never paid rent for the Franklin County property. That's just not accurate. That's not what the testimony was. The transcript will show that the candidate paid rent in legal services, that he did legal work for the landlord owed him money, and that the amount that was owed was discounted based on the rent itself. So it's just simply not accurate that no rent was paid. So, for all of those reasons, we believe the recommendation is incorrect. And we believe that we've presented evidence, and we established in our closing argument. I'm not going to just repeat that to you, but we believe that we've established both elements of residency through the Franklin County property. Physical presence. The candidate testified that he stays regularly at the Franklin County property. Intent to remain. He signed a 1-year lease. That lease requires him to either pay all of the rent if he leaves early without notifying the landlord, or if he does notify the landlord, to pay something like, I think about 4 or 5 times what his monthly rent was. That's indicative of an intent to remain. And so since we've established both of those, even if the hearing officer is correct that residency in Franklin County was abandoned when he moved to Williamson County, we believe that the evidence has shown that he has reestablished his residency in Franklin County. So I know I've just thrown a lot at you, so I'm happy to answer any questions that you have.
Mr. Fogarty, do you want to respond before we proceed with the question?
Yes, please. A couple points. With regard to impeachment evidence, there was no attempt to impeach certainly the testimony of the candidate. It is just that the candidate's testimony contradicted what was included in some of the affidavits offered by the candidate. Again, the hearing officer was best situated to determine whether or not what was being testified to by the candidate, really was truthful. His credibility was measured by the hearing officer, and so we would ask that the hearing officer's assessment of that credibility stand. With regard to the rent paid at this new Franklin County home, very conveniently, we asked for any evidence of rent paid, and none was given. Certainly, it is possible that the gentleman, the candidate, did perform legal services for the landlord, and he did say that he is a longtime client. That is true, but it's a very, very convenient arrangement for someone who is at the last minute rushing to reestablish themselves in Franklin County. This landlord also, who the affidavit said that he drove by several times. He lives in Georgia. He lives in Georgia. And it's just one idiosyncratic fact after another. The candidate rented his nice home in Williamson County and ended up buying that home just in October, and then purported to put it back on the market in the middle of October after this vacancy was announced. No for sale sign in the yard, no listing. But you look at Redfin, you look at Zillow, you look at Realtor.com. This home is not on the market. So if someone wants to sell a home, you market it. Nothing has been done. So at the end of the day, these are a lot of facts that were put together in order to try to, at the very last minute, reestablish in Franklin County. The hearing officer saw through it, and his judgment should be respected and should stand. And I'll answer questions as well.
Question?
Mr. Sharing,
Yes, ma'am.
your client changed his driver's license and his voter registration card to Williamson County, correct? And his statement that it was inadvertent seems a bit disingenuous. How about we just speak loudly?
I can do that.
Yep.
Yes, ma'am. To respond to your question, he did update his driver's license at that time. He did not, there was no evidence presented that he did update his voter registration. There was testimony that he was uncertain as to whether or not his voter registration had been updated. And so as a result, he re-registered in Franklin County out of an abundance of caution. His basis for registering his driver's license at that address, as he explained in his testimony, was that he was under the belief that his driver's license could only list that specific address, because at that time, that is where that was before he rented the Franklin County property. And so after that was done, after he rented the Franklin County property, and once he understood that he apparently found authority that he could list his law office, which is where he gets all of his other mail. So he re-updated his driver's license out of an abundance of caution to list that address. I agree with you that you know, in a perfect world or a perfect story to hold together perfectly, he would not have done it. But it does not change the fact that there was no contradictory testimony that was put on by the objector to undercut that.
How would one go about doing that? Put some testimony on to undercut the fact that he made a concerted effort to change the license, his address on his driver's license.
The objector could have found testimony from a third party who discussed the updating of his driver's license with him around the time that he did it. I don't know. I think there are multiple different ways that you could go about directly undercutting. But ultimately, it's not the candidate's burden to prove what his intent was. It's the objector's to disprove it. And since there was no testimony put on by the objector, I agree with you. I'll just be really honest. That's a bad fact for us. But it does not change the fact that there was no testimony put on to undercut the stated intent by the candidate. And since there was none, that needs to be respected and accepted as true, because there's no reason that there's been no evidence put on to call it into question.
May I respond on that point?
I think. Want him to respond. We need to get to the other. Are there
I know.
any other
I
questions?
think we're ready.
Anybody else have any other questions? Any questions in Springfield?
No, ma'am.
I'd like to make a motion.
Thanks.
First of all, I think that there does not need to be any reference to the individual investigation done by the hearing officer in this case. I think that the record established by the hearing officer otherwise is sufficient to support the conclusion that the objector met their burden. And therefore, with that caveat in mind, I move that we accept the recommendations of the general counsel modifying the recommendations of the hearing officer and accept the objection.
And deny the motion to dismiss.
Deny the motion to dismiss.
Second.
Roll call, please.
Bella Croft,
Yes.
Ms. Craig? Yes. Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Turbin? Mr. Turbin? Mr. Brett?
Yes.
Vice Chair Donahue?
Yeah.
Chair Watson?
Yes,
Motion passes.
thank you.
If I could note briefly to Jordan and Springfield, if you could ensure that order is updated to reflect the exclusion of the hearing officer's research into the divorce proceeding, I would appreciate that.
Madam General Counsel.
Thank you. The next matter, agenda item 3B, Overturf versus Minson-Miner, 24 SOEB GP 119. Objector Overturf, represented by attorney John Fogarty, filed an objection to the nomination papers of candidate Minson-Miner, who seeks ballot access as a Republican Party candidate for the office of Circuit Judge for the Second Judicial Circuit, Tedeschi vacancy. Objector's petition argues candidate's nomination papers are invalid because she gathered signatures under the name Vanessa Minson M-Miner, whereas her name is Vanessa Minson, and that candidate created a new hyphenated surname that violates section 7-10.2 of the election code. Objector further alleges that candidate filed a false statement of candidacy because there is no voter named Vanessa Minson-Miner registered to vote at her given address. Candidate filed a motion to strike, which was fully briefed in the hearing, and in the briefing, candidate says Minson is her married name, Miner is her surname at birth, and because she is going through dissolution of marriage proceedings, and because she wants to make it easier for Franklin County voters to identify her by including her birth name, the name on her statement of candidacy complies with the law. The objector offered exhibits showing various records for different names for the candidate, including Vanessa Minson, Vanessa Minson-Miner, Vanessa Miner-Minson, and Vanessa Brielle Minson. The hearing officer relies upon the Oberholzer case, Oberholtzer, and the Shannon DiCiani case, SHANN-DICIANNI, cases that are cited in your summary sheets in your packet. And the hearing officer recommends finding the candidate's name on her statement of candidacy violates election code section 7-10.2 by creating an impermissible double surname, invalidating her nomination papers. The relevant portion of that statute reads, quote, "In the designation of the name of a candidate on a petition for nomination or certificate of nomination, the candidate's given name or names, initial or initials, a nickname by which the candidate is commonly known, or a combination thereof may be used in addition to the candidate's surname." Because the hearing officer recommends sustaining the objection and removing candidate from the ballot, he recommends finding objector's argument that candidate filed a false statement of candidacy is moot, and he specifically finds that she had no intent to deceive in using Vanessa Minson-Miner on her statement of candidacy. The candidate could not be here today. She has court hearings, but she did file exceptions to the hearing officer's recommendation, but I did not find any of them to be persuasive. The hearing officer recommends, and I agree, that the candidate's motion to strike should be denied, that the objection should be sustained, and that candidate Minson-Miner's name should not be certified for the March general primary ballot as a Republican Party candidate for the office of Circuit Judge for the Second Judicial Circuit.
Since she isn't here to defend, can I just make a motion that we accept the general counsel's recommendation? Sure. I would move that we accept the general counsel's recommendation in regard to, 3E. Here,
Second.
Second.
Roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig? Yes. Ms. Genovese? Yes. Ms. McCory?
Yes.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
Thank you. Thank you, Amy. There's something wrong with my microphone, now. Madam General Counsel, I think we're gonna take a brief break before we begin with the presidential candidates. So what is the time now?
10:07.
10:07? Okay, so 10 minutes, 10:17, well, let's do 10:20. 10:20, recess to 10:20, thank you.
There. Oh, yeah. Say that. When I go, yeah.
I'm just confirming the.
Go ahead. Yes, and there's a little bit of a switch. I just texted Mr. Gessler to make sure that he's aware. So
Is Mr. Gessler aware?
I don't know. I just texted him. As Jack Bauer would say, I thought I'd have more time.
Over by the soundbar.
Excuse me.
Over by the TV.
Oh. We're back on, sir.
Get started. So the-
You guys, so we have quiet. They're starting again in Chicago. Thank you.
are we ready in Springfield?
Yes, ma'am.
Are we ready in Chicago now?
Yeah.
Madam Jones? I beg your pardon?
I'm sorry to interrupt. Mr. Gessler is on, so. Just.
Thank you. General Counsel,
Thank you.
I understand that we're shuffling the agenda somewhat. And
We
that we're
are,
gonna be
so-
starting with C.
Sure. So yes, we're going to consider objections to established party presidential preference and delegate candidate nominating petitions for the March 19th, 2024 general primary election. We are shuffling the agenda as the chair has decided, and starting with agenda item 4C. Holly, Hickman, Cintron, and Baker versus Trump, 24 SOEB GP 517. Objectors Anderson, Holly, Hickman, Cintron, and Baker filed an objection to the nomination papers of candidate Donald J. Trump, who seeks ballot access as a Republican Party candidate for the office of President of the United States. Objectors are represented by attorneys Lederer, Pierce, Truesdale, Tresnowski, Fine, and Mullen, and candidate is represented by attorneys Merrill, Gessler, and Nelson. Objectors allege that candidate's statement of candidacy contains a false swearing in violation of section 7-10 of the election code that he is qualified for the office, when they argue candidate is disqualified from holding the office of president under section 3 of the 14th Amendment to the US Constitution, which I will call section 3 throughout our conversation today. Because candidate previously swore an oath to support the Constitution of the United States, but had engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. Objectors allege that the events leading up to and on January 6, 2021, when the United States Capitol was breached by rioters, constitute an insurrection or rebellion, and that candidates' involvement in those events amounts to engaging in the insurrection. Both sides filed dispositive motions, which were fully briefed and provided in your packets. I'm not going to explain every argument made by each side in the nearly 250 pages of briefing, but I will list a few for you to be aware of. Objectors' papers argue there was a scheme to overturn the government and prevent the peaceful transition of power, which included violence and constitutes an insurrection, that the word engaging in an insurrection includes providing any voluntary assistance, and candidates' efforts to prevent the certification of the 2020 election results, his ellipsed speech that allegedly instigated violence, and his social media posts constitute engaging in insurrection. That deciding the question under section 3 is within the jurisdiction of the board under section 10 under the election code. Within 10-10 of the election code. Section 3 applies to the office of president, and that the Colorado Supreme Court recently correctly determined that the candidate is disqualified from the presidency under under section 3 in Anderson versus Griswold, as the hearing officer recommends. And the sites for Anderson versus Griswold are in your summary sheets. That decision was rendered on December 29th, 2023. Candidates' papers argue this board lacks jurisdiction to decide the section 3 14th Amendment question. This case presents a non-justiciable political question. Disqualification under section 3 can only be addressed through procedures prescribed by the United States Congress. That section 3 does not apply to the office of president. that objectors have not adequately alleged the candidate engaged in insurrection, and the facts alleged by objectors cannot establish he did so as a matter of law, and that genuine issues of material fact prevent the grant of summary judgment. The parties entered into stipulations to enter in the record in this matter most, but not all, of the exhibits and transcripts from Anderson versus Griswold. A hearing was held before the hearing officer on January 26, 2024, at which both sides made arguments and presented evidence that was subject to their previous stipulation. The hearing officer issued a written recommendation in this matter. The hearing officer recommends granting the candidate's motion to dismiss because the board is unable to decide whether candidate is disqualified by Section 3 without embarking upon constitutional analysis. He finds the board is not permitted to engage in such analysis. In making this recommendation, the hearing officer noted that the objection process in Illinois is much shorter in time than it was in Colorado in Anderson, lasting less than 2 weeks in this case. And it leaves no time for meaningful discovery or subpoenaing of witnesses needed to adjudicate the factual claims. Further, the Illinois Supreme Court in Goodman versus Ward and Delgado versus Board of Election Commissioners has prohibited the board from addressing issues involving constitutional analysis. If the motion to dismiss is granted for lack of jurisdiction, the hearing officer implies, but does not state, that the objection should be overruled and candidate Donald J. Trump's name should not be placed. Oh, excuse me, I should be placed on the ballot for President of the United States. However, the hearing officer recommends that if the board declines to grant candidates' motion to dismiss, the evidence presented at the hearing proves by a preponderance of the evidence that candidate in fact engaged in insurrection within the meaning of Section 3, specifically referencing a social media post regarding former Vice President Pence during the breach of the Capitol. As a result, should the board decide it has jurisdiction to decide the Section 3 question, and it should deny the motion to dismiss, the hearing officer recommends that candidate Donald J. Trump's name should not be placed on the ballot for President of the United States. Both sides filed exceptions to the recommendation. So if candidate's motion to dismiss is granted as recommended by the hearing officer, I concur in the ultimate result, which is to overrule the objector's petition and certify candidate's name to the March 19, 2024 general primary ballot. However, to ensure that a reviewing court has sufficient reasons to affirm the board's decision in this matter, I'm offering several different options for the board to discuss as possible resolutions of this case. My goal is to reduce the possibility that a reviewing court remands the matter back to the board for further proceedings. First, I'd like to clarify for the board that even if the board does not have jurisdiction to engage in a constitutional analysis of Section 3, the board does have statutory jurisdiction to pass upon objections to nomination papers filed for the office of president under Section 10-10 of the Election Code. I read the hearing officer's jurisdictional recommendation to presume that this board must actually decide whether candidate is disqualified under Section 3 in order to assess the validity of the nomination papers under Illinois law, and that it is the constitutional analysis needed to reach that specific decision that the board cannot perform, in his opinion. Putting aside the Section 3 question, the board unquestionably has a statutory mandate to rule upon objections filed and determine the validity of nomination papers objected to. And this board sits as the state officer's electoral board solely for that purpose. The board could consider a way to rule upon this matter solely based upon state law, which avoids the question of the board's jurisdiction over the federal constitutional issue. I will call this option number 1. The objectors allege that candidate filed a false statement of candidacy when he swore under penalty of perjury that he was legally qualified to hold the office of president. However, the candidate has argued throughout this proceeding that he is qualified to hold the office and that he is not disqualified by Section 3. My recommendation in option number 1 is to find that following the evidentiary hearing in this matter, there has not been sufficient evidence presented to demonstrate that candidate was untruthful on his statement of candidacy in violation of Section 7-10 of the Election Code. Legal qualifications for Illinois offices generally involve the application of Illinois law to facts personal to the candidate, like whether they live in the district, have lived in the district for a long enough period of time, or whether they hold the correct professional qualification. To the extent the candidate swearing he is legally qualified for office must mean he is not disqualified under Section 3, this involves an analysis of complex facts as well as law, many of which involve actions by others at the Capitol on January 6th, for which he was not physically present, making it more difficult for him to know whether in fact he is legally qualified. Illinois law favors ballot access, which is a substantial right, and absent some evidence that candidate had some awareness that his statement of candidacy is false, I do not believe that alone is sufficient to invalidate his nomination papers. I'm not advocating for adoption of a criminal law perjury standard in a non-criminal matter. In this case is determined on a preponderance of the evidence standard, but not just any alleged mistaken statement on a statement of candidacy should be sufficient to deny ballot access to a candidate. In the case of Illinois candidates running for Illinois offices, other requirements of the Illinois compiled statutes and the Illinois Constitution work together with the election code to ensure that only qualified candidates obtain access to the ballot. But as to federal candidates, the only statutory authority Illinois law gives to prevent a federal candidate's ballot access is if the candidate's nomination papers are not in compliance with the Illinois election code. And the singular way this board's process touches a federal candidate's substantive qualifications for office is if the candidate falsely states they're qualified to hold the office and a duly filed objection is sustained for that reason. And I am not convinced here that the candidate has filed a false statement. To the extent that Illinois law does require that candidate actually meet all legal qualifications for office, state and federal, in order to have valid nomination papers, then I recommend adopting the hearing officer's argument that the board lacks jurisdiction to engage in the constitutional analysis necessary to decide whether Section 3 disqualifies candidate from holding office. Even if the board believes it has jurisdiction to analyze and decide the Section 3 question, I discourage the board from doing so today. A number of legal questions must be decided, including whether Section 3 applies to the office of president, before it would be appropriate to determine the candidate did or did not engage in insurrection. The hearing officer's recommendation does not make recommendations on certain preliminary legal questions. So if the board considers those facts without first evaluating these legal questions, this could result in reversal by the courts and possible remand to this board for further proceedings. I think it's in the interests of everyone that the board's decision after today proceed up through the court system towards a resolution. I would like to better understand which direction the board is headed in this ruling before we talk too specifically about ruling on the dispositive motions filed by each side. But in any event, I recommend finding that the objection should be overruled and candidate named Donald J. Trump should be certified to the March general primary ballot as a Republican Party candidate for the office of president. No. I understand that we're asking the parties to limit their arguments to 15 minutes each. If the objectors can begin.
That's correct. Counsel for the objection.
Thank you. Madam Chairwoman, Madam Vice Chair, members of this honorable board, counsel for candidate, Mr. Trump, and Madam General Counsel. I'm Matthew Peters, and along with my colleagues arrayed to the left and one I hope zooming in, we represent the petitioner objectors in this matter. And it's an honor to do so. As the General Counsel has told you, and as I'm sure probably the weightlifting that you've engaged in from the paper, unless you have it all electronically, has shown you it's a rich record. A lot of legal argument and writing, a lot of evidentiary material presented to you. And I think without being immodest, the lawyers on both sides did a good job. This has been well submitted to you. And while I am passing out introductory compliments, the hearing officer did a remarkable job in a very short period of time, consuming a small mountain of legal argument and evidence and issuing a very thoughtful bid. He received an extensive record that included our objection, which was a fulsome document with argument and citation to authority, the trial transcript of the Colorado case, the Anderson litigation, the factual findings, not the conclusory comments, but the factual findings of the January 6th Congressional Committee. Very extensive evidentiary material in addition to that, comprised of tweets and public statements by the president, largely undisputed, those facts, and detailed motions, dispositive motions from both sides. A motion to dismiss from Mr. Trump's counsel and a petition for a ruling in our favor, either on the evidentiary record or in summary judgment for the objectors. Judge Erickson recommended, as the general counsel has just indicated, that our objection, our petition be denied on the basis of one of the grounds alleged in the motion to dismiss, alleged by the candidate. And that is that this board lacks the legal authority to determine complex constitutional questions like this that require both legal determinations and factual determinations. As a second ruling, or recommended ruling, I'm sorry, Judge Erickson, the hearing officer, said that if instead this board finds that it does have jurisdiction, it should, based on the record adduced, the factual record adduced, and the law presented, find in favor of the objector petitioners and rule that Donald Trump may not appear in the presidential primary ballot because he has in fact engaged in an insurrection in violation of Section 3 of the 14th Amendment of the United States Constitution. In so doing, by the way, the hearing officer recommended denial of our petition for summary judgment. That is, the secondary ruling that he recommended, should you find authority to act, is one based on the evidentiary record and determinations of evidence, not on summary judgment and lack of undisputed, lack of facts in dispute. And secondly, implicit in his ruling, I think it is fair to say, he found the other grounds alleged in the motion to dismiss to be without merit. Thereafter, your general counsel recommended, for the first time only yesterday, and again reiterated today, that you should dismiss this objection on purely state law grounds, based on a novel interpretation of the Illinois Election Code, which I must emphasize is completely unsupported by its text. Council's proposal would add a scienter, intent element to the provisions of certification of qualification for office that's simply not there in the code. It would be a determination of the mandatory certification requirement so that the requirement of accurate certification, which is, I think, undisputed, that is what the requirement is under the law, that it be accurate, would be complied with regardless of the truth. If when a potential candidate certifies that it's true, he's not knowingly lying. I submit to you that is not the law under the election code, and that is not the law under any case that has ever been decided in the state of Illinois. Now, we first heard this interpretation, not from the pleadings of the candidate, but in your general counsel's recommendation, which we received late yesterday. With all due respect to the general counsel, I mean that sincerely, and to this board, the suggestion is not lawful, and it should be rejected. There is no quote unquote knowing violation exception to the mandatory requirements of the Illinois Election Code of certification by each candidate that they meet the qualifications for the office they seek. If they do not meet those qualifications, they may not be on the ballot, regardless of the good intent. We heard some cases this morning about residency, about name change, and certainly in the case of the residency case, it is quite possible that the judicial candidate in that case thought that by renting an apartment in, I think it was Franklin County, don't hold me to that, but in Franklin County, that he or she was in compliance with the law. Well, you found he or she was not. I apologize, I don't remember the gender of the judicial candidate. And you didn't find that based on what the candidate thought was legal compliance, but rather on legal compliance. I want to add parenthetically that while it would not help Donald Trump here in any event, for the evidence clearly establishes that the certification that he made at the time he made it was false, he was certainly well aware that his conduct in seeking to prevent the certification of the results of the presidential election was unlawful, was illegal. He had been told so repeatedly by his own lawyers, by the Attorney General of the United States, by other high-level officials in the United States Department of Justice, and by his own campaign staff, as well as the Vice President of the United States. I submit to you that's a fairly fulsome record upon which to presume he knew that trying to prevent the peaceful transfer of power was illegal. He was well aware, undisputed, of the invasion and seizure of the Capitol, and indeed has acknowledged that it was an insurrection under the meaning of the third section of the 14th Amendment of our Constitution. That it was an insurrection was found overwhelmingly by both houses of the United States Congress in the most significant bipartisan vote in years, and was admitted by counsel for Mr. Trump on the floor of the House during his impeachment proceedings. So I think you could find knowing violation of the law quite easily on this record, but the truth is there is no such scienter requirement in the Illinois Election Code. This board is what is inartfully called by lawyers a creature of statute, and only has those powers that you are given by statute and required to undertake under the constitutions of the state of Illinois and the United States. I pause and note every governmental entity must comply with those two constitutions, regardless of what their statutory mandate is. I'm thinking about that. There's no dispute and no unclarity. What you may not do is graft new elements, new requirements onto the clear language of the Illinois Election Code. On behalf of the petitioner's objectors, we request that you grant our objection, adopt the recommended factual findings presented to you by Judge Erickson as hearing officer, and deny the motion to dismiss in its entirety. A few comments, and then I shall pass the microphone to learned counsel for Mr. Trump. There is no question under the law, no legitimate question, law, that this board not only has the authority to determine an objection based on the United States Constitution, but indeed you have the clear mandatory duty to do so. When you signed up for this job, this burden came with you signing up for this job. You may not have anticipated a case of this complexity or of this degree of controversy, but that does not change your statutory and constitutional authority. This board has a long history of having applied constitutional challenges to statements of candidacy in the past, including in the case of candidate Marco Rubio, including in the face of challenges that this board had no such authority to make such a determination. Accordingly, Judge Erickson's and the general counsel's recommendations as to the motion to dismiss should be denied. There is no complicated or controversial or constitutional limitation on your powers. You must do your duty under the election code or as found elsewhere. There has been a mispresentation of Ward v. Goodman, the leading Illinois Supreme Court case in this area. A misrepresentation that in some way the Supreme Court said that this board could not consider constitutional questions. That is not what the Illinois Supreme Court said in that case. Indeed, it made it quite clear that this board must apply constitutional considerations in this case. What Ward v. Goodman said is really not a very controversial provision at all. It said that this honorable body, and indeed it's true for all administrative bodies everywhere in this country, may not declare statutes to be unconstitutional. Under our tripartite system of government, administrative bodies don't have that power. Only courts have that power. But administrative bodies, this one and every other one, must obey the Constitution, and to the extent that constitutional provisions dictate or impact the outcomes of the proceedings before you, you must obey the Constitution, just as I must obey the Constitution and everybody in this room must. But you to a higher level, because you're the government. The factual record that was found and recommended by Judge Erickson should be adopted by this board. On the basis of that record, this board should grant. That record shows, to more than a preponderance of the evidence, that the candidate, Mr. Trump, knowingly and voluntarily engaged in an insurrection to prevent the peaceful transfer of power for the office of the presidency, which transfer is provided for in the United States Constitution. The only proceedings to reach the merits on this question are unanimous on this point, that that is in fact what happened. He did indeed violate the law. It is also clear from this record that in an effort to prevent that peaceful transfer of power, I mean, Mr. Trump, this isn't a secret. As the sitting president, he made it clear that that was what he intended to do. He intended to stay in office because he claimed, with no factual or legal basis whatsoever, after having lost 60-some legal challenges around the country, he claimed that the election was somehow stolen with no facts and no legal authority. And based on that continued allegation, he took a leading role in organizing, facilitating, supporting, directing, and protecting a concerted, armed, and violent invasion and seizure and disruption of the United States Congress on January 6th. As the members of that body were gathering to fulfill their constitutional duty of certifying the electoral votes, target was to disrupt that process under our Constitution, which is indeed the peaceful transfer of power. This record is not only well established before you, it is unrebutted by any affidavit from the candidate. He stands silent before this board. Because of that largely unrebutted conduct, the candidate is disqualified to run for the office of president under Section 3 of the 14th Amendment to the United States Constitution. Accordingly, we submit the petitioner's objection should be granted. Ms. Malowitz has stated in her recommendations to this body that in order to, quote, ensure that a reviewing court has sufficient reason to affirm this board's decision in this matter, close quote, she offers different options to the board, as she has discussed and as her recommendation clearly presents. Different options, which she says, the goal of which is to reduce the possibility that a reviewing court remands the matter back to this board for further proceedings. While we may disagree with some aspects in the general counsel's recommendation, we wholeheartedly agree in that goal. We think that this honorable board should make a determination with regard to the matters pending in such a way that the appellate courts, and there will be appellate courts, this is secret, I think there will be no disagreement among counsel on that point. So the appellate courts have the ability to make a full and final determination without sending it back down here for more. While we fully believe that only the granting of our objection will be affirmed, we share the goal of this board making a record that will not be remanded for further proceedings. The proceedings before this board have been extensive and very thorough. There is a full legal and factual record which should be adopted by this board so as to present a complete record upon which the courts will make a final determination in this most important matter upon appellate review. With those remarks, I'm happy to answer any questions, and I will cede the mic over to counsel for Mr. Trump if there are no questions.
Do we want to take questions now, or do we want to allow the other counsel to proceed at this time? Counsel, please.
Members of the board and counsel and staff, good morning. My name is Adam Merrill. I represent the candidate Donald J. Trump. My co-counsel, Scott Gessler, who couldn't be here today, but is admitted in Illinois and was present at the hearing last Friday, is present via Zoom. Mr. Trump did not engage in insurrection as that term is used in the Constitution. It is a complicated legal term that has been rarely interpreted, and it wasn't even articulated correctly by the hearing officer in this case. And frankly, never should have reached it because there of the lack of evidence and because of the lack of jurisdiction. Mr. Trump has denied ever participating in an insurrection. In fact, Judge Erickson, the hearing officer, found that he didn't intend for there to be any violence. He never advocated violence. There's nothing in the record that suggested he did. And he always said all of his public statements and tweets on January 6th were to be peaceful. Now, there's been a lot of discussion. We believe that the general counsel's recommendation makes a lot of sense and should be adopted because you can't find an affidavit to be false without actual evidence that they knew of, the candidate knew of falsity when he submitted the affidavit and statement of candidacy. In this case, that didn't happen. Let me talk for just a moment about the evidence. And if there's questions about the evidence, Mr. Gessler spent 5 days in a Colorado courtroom. He's much more familiar with it and can speak to that. But in terms of the evidence in this case, there was none. The parties stipulated with respect to two things, that was that the some of the exhibits from the Colorado trial could be considered by the hearing officer. But there were all of the other objections concerning those exhibits were preserved. One of those main exhibits was the January 6th report. The January 6th report was a partisan report. It was done only by the only Congress people that participated were people who had already voted to impeach President Trump. And under those circumstances, Illinois rules of evidence, Rule 8038, doesn't permit the conclusions in that report to be submitted. We objected on that basis. We said we don't dispute its authenticity, but that was the limit of the stipulation. And we objected to it being considered for any other purposes. And within the report is what lawyers like to call hearsay within hearsay. It is simply not something that can be considered by the hearing officer, and it wasn't considered by the hearing officer, and it certainly is not something that can be considered by this board as proof of what the report suggests happened. In terms of the trial testimony, that was simply the parties stipulated it could be considered as former testimony, which is an exception to the hearsay rule. But what's not admissible under the hearsay rule are any findings containing expressions of opinion or the drawing of conclusions. And that is what the alternative recommendation of the hearing officer did. In addition to the lack of factual evidence in this record that's admissible before the hearing officer and before this board, the hearing officer never reached a number of key legal issues. And those issues included that this is a political question that is not capable of adjudication by the board or really a court. The 14th Amendment, the third section of the 14th Amendment, was meant to be enforced by Congress. Section 3 bars holding office, not running for office. And the president is not an officer of the United States, as that term is used in the Constitution, and therefore Section 3 does not apply to the office of president. There was no finding or ruling by Judge Erickson on any of those legal questions. So, under the circumstances, given the lack of evidence, given the lack of legal issues, we think that what makes the most sense is to follow the recommendation of the General Counsel and say that the board doesn't have sufficient evidence to find that statement of candidacy was inaccurate or false, and therefore overrule the objection. If the board is not inclined to do that, then it's always an awkward thing to argue to a board that the board doesn't have authority, but Section 10-10 simply does not give the board the authority to weigh into complicated federal constitutional issues. The language of the statute, it talks in terms of nomination papers being in their proper form, whether they were submitted on time, and under conditions required by law and whether they are genuine. It does not speak in terms beyond that. And the couple of examples involving presidential qualifications, they make sense if you adopt Ms. Malowitz's approach, the general counsel's approach, that because those were clear-cut situations involving former President Obama and Senator Rubio, where a birth certificate, for example, could be provided, and that was enough for the board to be able to conclude whether they were qualified to run for president of the United States. This is far different. This is an alleged disqualification for running, for holding office, not even running for office, and it's inappropriate and not within the board's authority to do that. And no Illinois court has ever suggested that the board has this authority. So with that, we would recommend that and urge the board to not weigh into this. Mr. Pierce suggests you have to weigh in. We disagree. Nothing, there's no precedent of any court in Illinois or anywhere else that suggests that this board has to weigh in on this issue. Most of the states that where objections like this have been made have declined. And only two places, Colorado and Maine, have agreed to have concluded that they have the jurisdiction to hear this issue and to determine that Mr. Trump shouldn't be on the ballot in those states. And the Colorado case is now before the U.S. Supreme Court. And it really, under all of these circumstances, makes no sense for the board to weigh in and deprive Trump of and the voters of Illinois to the ballot access that Illinois law favors, and as a general counsel pointed out. So with that, unless the board has any questions, I'm available, and Mr. Gessler in particular, if there's any factual questions, is available to discuss this issue further. But we would urge the board to overrule the objection and allow Mr. Trump his name to appear on the primary ballot.
Do you wish to add anything else?
Very briefly, Madam Chairwoman, and I mean really briefly, not lawyers briefly.
Yeah, really,
Really
really.
briefly. It is simply untrue that the hearing officer found that Mr. Trump did intend violence. Let me read to you the language from the hearing officer's recommendation in that regard. This is at paragraph 7, I think, of his numbered paragraphs. Close. I'm sorry. I hope the numbers, I'm not going to do that intro again. Quote, even though the candidate may not have intended for violence to break out on January 6, 2021, he does not dispute that he received reports that violence was a likely possibility on January 6, 2021. Candidate does not dispute that he knew violence was occurring at the Capitol. End of quote. That's a far cry from finding that Mr. Trump did not intend violence. He certainly watched it and did nothing to stop it. I am happy to respond to the other issues raised in the motion to dismiss if you have questions. I think we've handled all of that fully in our briefing. I know you've got a busy morning, so I will add just one more sort of reiterative point. When we use the January 6th report in this proceeding, we did not use the conclusions in that report, but only the factual findings. We do not seek for this board, to consider those conclusions. We haven't introduced those conclusions, only the factual findings. And lastly, look at the Supreme Court's guidance in Goodman. It is other than what has been represented. With all due respect, you are obligated to rule in this matter. And with that, I answer any questions or we stand down.
If Mr. Gessler may just be permitted to just respond to some of the facts.
Mr. Gessler.
Issues.
Thank you, Madam Chair. And I also want to thank the board for its courtesy in allowing me to appear by Zoom. I would just like to clarify a couple things very briefly. With respect, a slight misstatement by my co-counsel, there is one court in the entire United States, that's Colorado, that has sought to adjudicate and exercise jurisdiction over these issues. Every other court has rejected it. In Maine, it is the Secretary of State who chose to go forward with this, and she sought the endorsement from the courts who have in Maine ordered her to stay any decision she has pending an outcome from the United States Supreme Court. So the Maine courts themselves have both the Superior Court and the Law Court, that's the Supreme Court of Maine, have exercised discretion and chosen not to wade into these issues, and properly so. So the vast weight of discretion and authority across the country is to not adjudicate these issues. I would note a few things. The January 6th report has multiple opinions and legal conclusions in there that are intertwined with facts. For example, with respect to President Trump. Furthermore, to the extent that the objectors rely on some of the factual findings, those are unclear at best, and President Trump has never had an opportunity to cross-examine or to develop witnesses to rebut any of that because of the procedural deficiencies we have faced in other states. And this board, I think, has a sense of those procedural challenges, which Judge Erickson properly pointed out, to determine whether or not there was an insurrection against the United States occurring a year and a half ago, 800 or 1,000 miles away, by this particular, by the board, when President Trump has never been afforded any opportunity for discovery and whatnot. So, for example, I mean, several comments that that the objectors have made, I think, are simply not supported by the record. For example, he says, and I believe Judge Erickson said that that President Trump made false claims about the election. Yet at the hearing in Colorado, Representative Swalwell, an eyewitness testimony, a political opponent of President Trump and one who is fighting him in court in several areas, specifically testified that he and his Democrat colleagues believed that President Trump held sincere beliefs about his position with respect to the election. That was eyewitness testimony, as opposed to sort of these amorphous statements, which we've not been able to test because they're derived from the January 6th report. Objectors have claimed that Congress overwhelmingly voted that there was an insurrection. That simply isn't true. In the House of Representatives, it was mostly a partisan vote. 54% voted that President Trump had incited insurrection, and 46 voted against that. And yet the January 6th committee was comprised entirely of committee members who had viewed, and this is from testimony from the Colorado hearing, that it was an obvious fact, their belief with respect to President Trump's participation and their claim that it was an insurrection. And that was the basis in which the January 6th report came about. And so we dispute very strongly not only that, but also many of the facts derived from the January 6th report. At the Colorado hearing, Representative Ken Buck spent 28 years as a prosecutor. He actually served as a staffer in the Iran-Contra hearings, so he's familiar with controversial reports. He viewed the January 6th report as akin to him showing up in court as a prosecutor and prosecuting a case without the defense or defense counsel ever being present. And that's how unfair we believe it was, and that we think many of the facts show. There was never an admission, and there never has been an admission by President Trump, anything near that January 6th was an insurrection. Objector statements stem from a statement by President Trump's counsel on the floor, who said, "We are not here today to determine whether or not an insurrection occurred. On that point, everyone agrees." And when he said on that point, everyone agrees, he was pointing out the fact that everyone agreed that the issue that he was talking about at that moment was not insurrection. The point was not that he or anyone from in President Trump's camp, or he as an agent of President Trump, had agreed that January 6th was an insurrection. And in fact, that interpretation is proper because it's grammatically correct and consistent with everything President Trump has said for for the last year and a half.
Sorry, Attorney Kessler.
Yes,
We'll
ma'am.
have this off at this time.
Okay. I'm sorry, could you repeat that, Your Honor? My connection may not have picked that up.
We'll have to cut this off.
Okay. No problem. Thank you for your indulgence. If you have questions and want to wade into these factual issues, I'm fully prepared to do that. But we believe that this board does not need to reach those issues. Thank you.
Okay, do we have any questions in Springfield from the members there? Member
not-
Chavez, Member Craig,
Not at this time. Thank you.
do we have any questions here in Chicago? From any of, any questions? No? Okay. Do we have a motion at this time?
Brief discussion first. Before motion, is that right? I have a motion.
Please.
Thank you. It is a phrase in the law or an axiom that hard cases make bad law. And I think we can all agree that that applies to this case and the situation that lays before us. I think that the general counsel has made a good job and tremendous effort into protecting the jurisdiction of this court, protecting our authority, and making sure that there is a record sufficient for the parties to fully litigate this matter upwards on appeal, as both have said that they intend to do regardless of the outcome today. So I commend the general counsel for that. The general counsel advises us that if we pass on the constitutional question, we would be exceeding our authority under the election code. And I think it's important to reflect on what that would mean for this board, specifically if we were to do so. If we exceeded our authority and went beyond the documents and the nominating petitions and looked at the underlying conduct that was alleged in this case, what I believe we would see is a opening of a floodgate of litigation, not necessarily before this board, but before all of the electoral boards that look to us for guidance on all the different election matters across the state. The fact is that this board sets the standard, the legal standard and the procedural standard for all the other electoral boards across the state. We're talking about the county elections, the village boards, school boards, and the like. And if we allowed them and gave them authority to say, don't just look at the papers, but actually look at underlying allegations of misconduct, that would open up floodgate. One of the things we've seen over the years in this board is that challenges in these local elections often are the fiercest of any contested case, far more so than at the presidential level. And I think that what we would see if we exceeded our authority is every possible school board candidate would seek to challenge the qualifications based on some sort of alleged criminal conduct. And this board and the other electoral boards are certainly not constituted to do so. There was wisdom, I believe, in the legislature when they created the election code and said what our authority was, and by that, what our authority wasn't. And when we all took an oath to serve in this role, we would be violating that oath if we exceeded our authority and wade into the constitutional question against the recommendation of the hearing officer and against the recommendation of the general counsel. I'd also note that in addition, so that the record is clear, I think that the relief that objectors are seeking is one of ballot forfeiture. And under our statute, they simply haven't presented a case for ballot forfeiture as well. So with all of those caveats in mind, that's the rationale in my mind. Maybe others have others. But I would move that we accept the general counsel's recommendation that the candidate did not file a false statement of candidacy, insofar that there is some sort of statement necessary. I think that we do not have jurisdiction to weigh into the constitutional issue and to decide the question of whether the candidate engaged in an insurrection in violation of Section 3. Therefore, I further move that we deny the motion for summary judgment, grant the motion to dismiss for lack of jurisdiction, and therefore overrule the objection.
Can I ask one question about the motion? So is the board or is the motion suggesting that Illinois law does in fact require a candidate to not be disqualified by Section 3 in order to appear on the ballot? Or is this sort of an alternative that if the, uh,
It's it's in the alternative.
it's in the alternative.
Correct.
Okay, okay.
There a second?
I get that motion.
Roll call.
Ms. Bella Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
I'd like to make a statement before I rule on this. I want it to be clear that this Republican believes that there was an insurrection on January 6th. There's no doubt in my mind that he manipulated, instigated, aided and abetted an insurrection on January 6th. However, having said that, is not my place to rule on that today. So I will say yes to the motion as far as not having jurisdiction to rule on that fact today.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
Thank you.
Thank you.
Madam Chair, can we take a 10-minute break?
Yes, let's take a 10-minute break.
Thank you.
Well, the time now is.
You want to
Right down.
Already. Oh.
Back from recess. Everybody ready in Springfield?
Yes, ma'am.
Madam General Counsel, you want to proceed?
Thank you. We're moving back to agenda item 4A, Smith and Conrad versus Biden, 24 SOEB GP 118. Objectors Smith and Conrad filed an objection to the nomination papers of candidate Joseph R. Biden Jr., who seeks ballot access as a Democratic Party candidate for the office of President of the United States. Candidate is represented by attorneys James Morphew, Kevin Morphew, and Michael Casper. The objector's petition alleges that candidate's statement of candidacy was notarized by a notary public commissioned in the District of Columbia, which they claim does not meet the requirements of Election Code Section 10-5. Candidate filed a motion to dismiss objector's petition and motion for summary judgment. Candidate argued, among other things, that the objectors cite to the wrong articles and section of the election code. The candidate's nomination papers were filed pursuant to section 7-10, governing candidates seeking nominations by established political parties, not under section 10-5. Additionally, under the Uniform Recognition of Acknowledgements Acts and Oaths and Affirmations Act read together, Illinois recognizes out-of-state notarizations performed by notaries licensed in the relevant jurisdiction, citing to Frost versus Cook County Electoral Board, where the court affirmed the dismissal of an objection to nomination papers based upon a non-Illinois notary public performing the notary functions outside the state of Illinois in the state of licensing. And candidate also argues that the state board presidential preference and delegates guide indicates that use of a local notary outside Illinois is permissible for candidates for president. The objectors responded relying on the case of Nobelok versus Electoral Board for the city of Granite City, in which a Missouri notary notarized a statement of candidacy for an Illinois candidate in the state of Illinois, and the nomination papers were invalidated as a result. Candidate filed a reply and a hearing was held, but no evidence was taken. The statement of candidacy was attached to the objector's petition. The hearing officer recommends granting the candidate's motion in its entirety, adopting the reasoning in the Frost case and distinguishing the Nobelok case. Nobelok is Knobelloch. If the board wants its ruling to be even more specific, it can find that the motion is granted as a motion to dismiss as opposed to a motion for summary judgment, because this objection raised a question of law that required no evidence outside the statement of candidacy. Interestingly, this board ruled on a case like this in 2020 in Boot, B-O-U-T-T-E versus West, case number 20 SOEB GP 508. The objector challenged a statement of candidacy of candidate Kanye West, whose notarization had occurred in Florida by a Florida notary. This board overruled the objection, expressly finding that executing a statement of candidacy before a Florida notary while in Florida satisfies the election code's requirement. The hearing officer recommends, and I agree, the objection should be overruled and candidate's name, Joseph R. Biden Jr., should be certified for the March general primary ballot as a Democratic Party candidate for the office of President of the United States. Now, I see that objector Conrad is here. Is objector Smith present?
You're down in Springfield, that's my knowledge.
Okay. Springfield, can you confirm objector Smith is down there?
Yes.
Yes.
Okay, great. Thank you. Well, I will turn this over to the parties.
Still morning, right? Good morning. I am Timothy Conrad, objector pro se. Beth Finley Smith is in Springfield, present via teleconference. I'll be brief about this because my main exception to this whole thing is that the state's interest in the notaries. That if we needed to subpoena this notary for whatever reason, that we could not because it's out of state. And if we were, that being able to do that, it creates a conflict because the state does not have reach beyond its own borders. In this case specifically, if for example, if we were to try to get a hold of this notary and ask if this candidate was competent or capable of swearing the oath that or affine to what he was affine to on the statement of candidacy, we could not do this. And it strikes me really strange that this individual who supposedly notarized this document could not come here to this state and commit that act, but can do it elsewhere. And that being said, I will rest and defer to my co-objector if she has anything to say.
Would you like to come up? Right.
The other objector available in Springfield to make a statement at this time?
You could just tell them that.
Yes.
We are having trouble hearing.
If you sit right there.
I have nothing further to add.
We still can't hear you.
I have
Nothing.
nothing to add.
Nothing further, Madam Chair.
He's not turned off.
Counsel for the candidate, you may proceed.
Thank you, Madam Chair. Oh, no, I'm green now. I think that's Michael Casper.
Devin Morphew.
For the candidate, President Biden. When we first got this case, my immediate reaction, oh, this is easy. This is the same case that I represented President Clinton for 18 years ago when he was running for re-election. Exactly the same. District of Columbia notary in the District of Columbia. And so then I went through my files and I found it and I realized it wasn't 18 years, it was 28 years ago. Which I'm still wrapping my brain around the fact that I've been sitting here for 30 years, but we think that the hearing officer's recommendation and the recommendation of the general counsel should be accepted. The Uniform Recognition Act applies on all floors here. That case was in 1996. The case is called Bernie versus Clinton, B-U-R-N-Y, court reporter. And this board unanimously rejected the objection and obviously sustained President Clinton's candidacy. He was elected. I believe it happened again to perhaps a better known candidate, even in Kanye West, but we would ask that you accept the recommendation.
So the recommendation is to grant the motion to dismiss, that the objection be overruled, and that candidate's name should be certified to the ballot.
So moved.
Second.
Roll call, please, Amy.
Ms. Ellercroft? Ms. Ellercroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turbin? Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
Thank you, gentlemen. Madam General Counsel.
Moving on to the next case, agenda item 4B, Bouvet, Conrad, Newsom, and Hubbard versus Biden, 24 SOEB GP 119. I just want to confirm that we have all objectors present, either in Springfield or in Chicago. Gentlemen, if you don't mind stating your names.
Terry Newsom, NWSOM.
Timothy Conrad, CONRAD.
And our objectors, Bouvet and Hubbard, present here in Springfield.
No.
Okay, then it will be an option for the board to hold those two objectors in default for not arriving at this proceeding. All right, so objectors filed an objection to the nomination papers of candidate Joseph R. Biden Jr., who seeks ballot access as a Democratic Party candidate for the office of President of the United States. Candidate is represented by attorneys James Morphew, Kevin Morphew, and Michael Casper. Objector's petition alleges that candidate's statement of candidacy falsely swore under Election Code Section 7-10 that he is qualified to hold the office of president. Objectors claim candidate is not qualified for the office based on Section 3 of the 14th Amendment to the U.S. Constitution, because candidate previously took an oath to support the Constitution of the United States, and objectors allege he has given aid or comfort to enemies of the United States through various immigration and foreign policies with which they disagree. The candidate filed a motion to dismiss, which was fully briefed, and a hearing was held, at which the objectors requested that the hearing officer take, quote, judicial notice of certain records. The hearing officer's recommendation finds that the board does not have jurisdiction to determine the issue of qualification requirements of Section 3 of the 14th Amendment, relying on the Illinois Supreme Court cases of Delgado versus Board of Election Commissioners and Goodman versus Ward, which are cited on your summary sheets and which we've discussed at length today. Here, I fully agree with the hearing officer's next recommendation, which is to grant the motion to dismiss because the petition fails to factually and legally state a viable basis for an objection, as the allegations made involve candidates' official immigration and foreign policies, which do not equate to personally providing aid or comfort to enemies of the United States, and nomination papers cannot be invalidated over policy disagreements. I note that I believe the board has jurisdiction to grant the motion to dismiss for this reason, because under Section 10-10 of the Election Code, this board possesses both jurisdiction as well as a duty to pass upon objections to nomination papers filed to candidates. And this objection is so inadequate, both legally and factually, it cannot be said to adequately plead a cause of action for disqualification under Section 3 of the 14th Amendment. So I do not believe the jurisdictional issue needs to be reached in this matter. However, I do not recommend dismissing based upon the issue of whether Section 3 of the 14th Amendment applies to the office of president, as the hearing officer recommends, as it's unnecessary to reach this issue, given the recommendation to dismiss based on the legal and factual deficiency of the pleading. And it's also a controversial issue that the board does not need to tread into, in my opinion. The objectors filed exceptions to the recommendation, arguing the hearing officer should have taken judicial notice of public documents they wish to offer as evidence and made other evidentiary ruling arguments that should have been made in their favor. They also disagree that this is a policy dispute. So here the hearing officer recommends, and I agree to the extent previously stated, that the motion to dismiss should be granted. Candidate has submitted valid nomination papers. The objection should be overruled, and candidate's name, Joseph R. Biden Jr., should be certified for the March general primary ballot as a Democratic Party candidate for the office of President of the United States.
Counsel for the object.
Well, objectors pro se here, so counsel. We are not attorneys, so we didn't make the distinction.
Just state your full name for the
Timothy
record.
Conrad,
please.
sorry. And then we do come here as citizens of the state of Illinois in these concerns. That being said, we have asked for notice of very certain things, including the text of the 14th Amendment, and all sorts of documentations in support of our argument that the hearing officer summarily rejected. We take exception that the hearing officer did not accept any evidence that we had offered, despite them being publicly accessible and clearly authenticatable as they are taken from like White House press releases, Department of Homeland Security statistics and reports, as well as border security statistics and reports as well. So we like reiterate that we do take exception to hearing officer's inadmittance of evidence. That being said, you cannot grant the motion to dismiss because we have clearly stated our basis for argument and legal nature, and even submitted evidence in support thereof, which were rejected by the hearing officer. As to the merits of the case, opposing counsel and I had discussed that the 14th Amendment is moot and probably could render it to the courts for their decisions as opposed to this board. Anything you'd like to say, Terry?
Yeah.
Hi, Terry Newsom, pro se as well. And as the prior counsel on the Trump case made a statement that, he heard other cases, mentioned earlier today before he spoke, as well did I when he spoke. And I find it interesting that, we're being alleged that our information is not factual, hearsay, it's political, partisan, motivated, while at the same time we had to listen that Trump should be off the ballot for insurrection that was falsely claimed by the highly partisan J6 committee. It's identical as to what we're, is being alleged here, except the difference is with respect to our claims, we know that Biden ignored the Supreme Court remain in Mexico. He ignored that. That's not partisan. He ignored that himself. We also know that Biden, this is not hearsay, Biden left $8 billion in military equipment and weapons in Afghanistan in the hands of the Taliban. And now we know that those weapons are being used against our men and women in Iraq, including one of my relatives that are out there. So that's not hearsay. It's not partisan. That's a fact. We also know that Joe Biden went to the Supreme Court to try to force Texas to keep them from protecting their own borders from invasions of illegals, drug smugglers, Chinese that he knows are coming in, including over 300 terrorists that are entering our country and being infiltrated, especially into Chicago. I think we all know that. We're all experiencing it. None of that is hearsay. It's all factual. So I guess that, that's all I have to say, because as respect to the insurrection, there was no insurrection. That's false. There was no weapons there. Nobody went to overthrow the government. No one tried to listen to Trump. And if that's going to be a valid response from the other counsel, then that's highly partisan. These things that I mentioned are not highly partisan.
Thank you, Kevin Morphew, on behalf of President Biden. And briefly, to the motion to dismiss, the objector's petition fails to allege plausible facts that would entitle the objector to relief. And that failure to fully state the nature of the objections is not satisfied here. So the motion to dismiss should be granted. The objector questions the candidate's policy, his policy disagreements, and then they make the conclusion that those policies amounted to aid and comfort for the enemies. And that conclusion of law is not entitled to any presumption of truth for the purposes of the motion. In entertaining objections like this, where we don't agree with the policy of a candidate, is very dangerous and would set a terrible precedent. And the candidate's objection should be dismissed on those grounds. Even if they do determine that this policy, that this pleading standard was met, the objectors present no reliable evidence of any cognizable evidence that would amount to aid or comfort to the enemies of the United States on behalf of the candidate. Their submissions and exhibits that they offered are inadmissible hearsay. They cannot be truthfully relied upon for what they purport to be. They did not admit any public records, and the standards of judicial notice, if applied to the documents that they submitted, they do not meet those levels. These are not readily ascertainable facts. And so we ask that the motion to dismiss be granted, and that the objector's petition be overruled, and that the name of Josiah Biden Jr. appear on the ballot for the March 19th, 2024 general primary election.
Any questions in Springfield?
No, thank you.
Any questions of the board here? Is there a motion?
I guess I move to accept the general counsel's recommendation granting the candidate's motion to dismiss based on legal and factual insufficiency of the pleading, and overrule the objection and certifying Joseph Biden Jr. to the March 19th, 2024 general primary ballot.
May I ask one question about the motion? Are we wanting to default objectors Bouvet and Hubbard who did not show up?
You should amend to,
Sure. We're gonna move,
default.
amend the motion to add that we hold the objectors Bouvet and Hubbard in default for not appearing in today's hearing.
Second?
Yes,
Here,
second,
second.
second.
Roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCrory?
Yes.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes,
Motion passes.
thank you. Thank you. No, Council, we're on D now, right?
Yes, so agenda item 4D, Jones, Johansson, Sutherland, Johnson, and Smith versus Biden, 24 SOEB GP 522. Is there anyone present in Chicago or in Springfield on behalf of any of the objectors?
Do we have any objectors present?
None.
Jones, Johansson, Sutherland, Johnson, and Smith. Is anyone in Springfield?
None in Springfield.
Well, seeing none here in Chicago, we have,
I would move to, with proper adjournment,
to enter a default order.
I would move that we enter a default order in regard to, 4D, Jones, Jones, Johansson, Sutherland, Johnson, and Smith versus Biden.
And therefore, the objection should be overruled and the candidate's name should be certified to the ballot. Is that
Yes.
correct?
Absolutely.
Is there a second?
Second?
Roll call?
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCrory?
Yes.
Mr. Turbin?
Yes.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
And council, I do not have a default order handy in front of me, so you can either wait for it or I can email it to you later, whatever you prefer.
Yeah, we can send the email. Thank you.
Thank you.
Thank you, Madam
Thank
Chair,
you.
members of the board.
Madam Chair.
Gentlemen. Madam General Counsel, we're now doing objections / candidates withdrawn, is that correct?
That's correct.
May I proceed?
Agenda
Gentlemen,
item.
excuse me. Please have your conversations outside. Our board meeting is continuing. Thank you. Madam General Counsel.
Thank you, Madam Chair. Agenda item 5A through 5F consist of matters in which either the objector withdrew the objection or the candidate withdrew their candidacy. So I ask that the board make a motion to accept these withdrawals.
Move.
Second.
Roll call?
Ms. Ballard Croft? Ms. Ballard Croft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCrory?
Yes.
Mr. Turbin? Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
Thank you. So that's 5A, B, C, D, E, and F, is that correct?
Correct.
Thank you.
Yeah.
Is there a motion to recess the state officers electoral board and reconvene as the state board of elections?
There you go. Second. That's it.
Roll call, please.
I didn't catch who motioned in second.
The motion was to recess the State Officers Electoral Board and reconvene as the State Board of Elections.
We did not catch who made the motion and who seconded the motion.
I made the motion and, member Brett,
Thank you. Thank you. Ms. Ballard Croft,
yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCory?
Yes.
Mr. Turbin? Mr. Brett? Vice Chair Donahue?
Yes.
Chair Watson?
Yes,
Motion passes.
thank you. Is there other business at this time?
Oh, here's a general.
Yeah, but that's public.
Yeah.
There being no other business, we'll proceed to comments from the general public. We have a Lawrence Liggets, Ligas. Is he in Springfield?
Yes.
He is approaching the table.
If you'd like to sit right there at that first chair.
Is the mic close enough?
It is. It's not. Not on.
Oh, no, it's on.
Is it?
Yeah, it's on. It's fine.
Would you state your name, please?
And my name is Lawrence Ligas. It's Ligas.
Mr. Liggets, you have 5 minutes for public comment. Please proceed.
I'm a Chicagoland resident, but the nice people in Chicago suggested I come down to Springfield to share my thoughts. And I'm invited here in Springfield. I was expecting to be at the Capitol, but this is a great venue here. For clarity, I am a January 6th defendant. For 20 plus years, I've been fighting election criminality, demanding integrity in elections in the Chicagoland and Illinois. I have accomplishments to the point that I contacted the FBI in 2019 with severe election irregularities going on in 2018, where the state police, the attorney general, the Chicago detectives, Chicago police detectives were not interested or getting pressure not to investigate. So regarding that is one reason why I attended January 6th. January 6th, from my perspective, I was on the front line. I arrived at the Capitol at about 10 a.m. I came from the ellipse. I got to the ellipse right while sun was coming up. I noticed suspicious behavior. I noticed people that are normally not at Trump rallies. I never intended to go to a Trump speech. My goal there was to talk about the Trump voter rolls, the awareness that is needed to some of the issues of more funding for election security and accountability against people that were doing wrong with the election ballots. I am a pro-blue man. I respect the court system of the United States of America. I believe it's the best court system in the world. And I believe that if you see something suspicious, you say something. I felt that to do the best for the voiceless, and that's one reason why I'm sitting here, because I'm not part of any group. I'm not part of any left group, right group, center group. I'm more of a loner. I accomplish much more on my own. So I'm not a cultist. But when I hear people saying that January 6th was insurrection, I stand up strong against that. I call it an anti-Trump insurrection because of the people that I seen causing trouble. They ended up being anti-Trump people. What affected me was when I got to the Capitol, it took about a 20-minute walk. I noticed some heavily armed police officers. They had federal on their jackets. They were not FBI.
I went up to them, and I said, hey, there's a lot of suspicious, actions going on at the Ellipse about 15 minutes down the way. I said, I'm hoping that there's going to be a lot like you over at the Capitol because something has to be done because these people are angry and some of them are looking to start trouble. And they weren't interested. I said, well, could you walk with me to the Capitol? They said for visual reasons, they don't want us near the Capitol. I started raising a red flag. Then when I got to the Capitol, I said about 10 a.m., I was stunned, shocked. I saw 5 police officers. 5. None of them looked too serious. I then walked around. I thought maybe that there will be another 5,000 staging on the other end. I saw nothing except 2 suspicious looking guys that were looking at me suspicious. They were dressed in suits, maybe in their late 30s, 40. I went up to them. I said, and I introduced myself. I said, my goal here is to demand integrity in elections. And they're like, well, we're waiting for our escort. Words like that. So they led me to believe that the Capitol was open. Then after that, several media sources that knew me or knew of me, they started talking to me. And that's how I got the reputation of domestic terrorist #1, domestic active terrorist #1, because I was there early. I was looking to, find somebody to talk to about more funding for election security, accountability elections. But then I started hearing the buzz about a pipe bomb at about 1:10. Then I heard police on the mics about shots being fired in the Capitol. This was all erroneous. There was never shots in the Capitol except one shot to a small woman that was crawling in a window. So I believe that January 6th was not an insurrection, and I begged the board here to allow Trump to be on the ballot to give the voters a chance to vote because Chicago is the capital of murder and there's voter apathy going on, and we just need a good choice for the independent voters to come out. Thank you very much. Thank you for doing your good work. Thank you for everybody standing up.
Thank you, Mr. Liggis. Is there any more business to come before the State Board of Elections? If not, may I have a motion? Motion to adjourn? A second? Second. I don't think we need a roll call on that, do we? Do we? Roll call, Amy.
Ms. Ballard Croft,
Aye.
Ms. Craig,
Aye.
Ms. Genovese, yes, Ms. McCory,
Aye.
Mr. Durbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Board is adjourned.